working at the national level. She's a lawyer by profession and has around 14 years of work experience in technology laws, financial regulation, and corporate laws. At Vidhi, she focuses on developing legal and policy solutions to ensure that the innovation serves society in an equitable manner and responsibly. At Vidhi, she works with various government ministries, departments, agencies, regulators, etc., on some very relevant and interesting areas like digital public infrastructures, data protection, AI, digital safety, and digital competitions, etc. Uh, she is regularly invited to speak at national and international conferences on technology policy and financial technology. And she regularly writes for some of the top media houses in the country, like the Financial Express, the Hindu, and the Live Mint, etc. So, welcome, Shehnaz.
Thanks, Jyotirmoy. Thanks a
Yeah.
lot for having me.
Yes, thank you, Shehnaz. And just one, just before you start, I want to tell you that like we have been discussing this of late as well, that many time our focus is completely on the technology aspects, on development, on deployment. We make sure that things don't go wrong. But in all this rush and milieu, sometimes we lose focus on the legal aspects. We lose focus on the policy and governance aspects. And time to time, in the last 3 to 4 years, since we have been interacting on agricultural data exchange, some other aspects of data exchanges, and recently for the digital address work, right? You and your team has been acting as guardrails for us at CDPG, and I look forward to hear you. Yeah, so over to you. Thanks.
Thanks a lot, Jyotirmoy. I have a short presentation. I'm just going to share my screen, and if you can just let me know whether you can
Please.
see that or not. Yeah. Is this visible, Jyotirmoy?
Yes, Shanaz, we can see you. Yeah.
Yes, cool. Okay. First of all, thanks a lot once again, Jyotirmoy. I think with a pioneering institution like a center like CDPG actually talking about, you guys are leading the conversation on tech infrastructure and architecture for data exchanges in India. And I think it's quite heartening to see, when you talk about how important it is also to talk about legal and governance aspects of this. And I'm really thankful to you for this opportunity. So the focus of today's discussion, conversation is essentially on who bears the risk, law and liability in data exchanges. Very briefly, this is essentially so that we all are on the same page on what we mean by data exchanges. Essentially, in the last couple of years, we have seen various kinds of data exchanges that have emerged, which essentially facilitate secure and consent-based sharing of data between different entities. I'm not going into the technical details of it, but broadly, what we have seen is that over the course of the last few years, we should not, the way data exchanges have evolved, we should not perhaps see them as mere tech infrastructures, which is facilitating sharing of data, but these have become systems of trust, with many government agencies sort of looking at them as a form of a digital public infrastructure, and questions of public good, public interest also sort of arise with these. So that is why I think it's very important to ensure that these exchanges are not only technologically secure but also legally sustainable, and they sort of have equitable access. And keeping that in mind, so I think one important question that often comes up is that what happens if something goes wrong in this data exchange? There are different players in this ecosystem. How do we ensure, how do we know where does the buck stop essentially? Um, Again, in India, there are different kinds of data exchanges. These are some of the ones which we have seen that have emerged. These are obviously ones that the government has also backed some of these exchanges. And we will essentially now talk about broadly some of the key players in this ecosystem. Any conversation about law, liability, is only relevant once we understand what the key players of the ecosystem are. And the talk today will focus on some of these key players, essentially the platform operator of a data exchange platform, which is essentially the entity which is controlling and operating the platform. In the context of many government-backed data exchanges, this happens to be a government entity. Then you have data providers or contributors. These are entities which are contributing data sets to a platform. And then you have data users, which are essentially entities which are accessing the data sets that is available on this platform. And that data sets can be accessed for various purposes for which for various legitimate purposes. These are the core players, and conversations around liability, conversation around responsibility, applicable laws will typically move around these three key players. Having said that, if there are also personal data sets that are available on a platform, today the question of consent managers come up, because again, this is a new type of entity which is coming up, which is also recognized under the Digital Personal Data Protection Act in India. And going forward, it will be interesting to see how this also gets integrated into the ecosystem. And last but not the least is the end users. Today, any data user who is accessing data from a data set, from a data exchange platform, will be using that data sets to build products, to build solutions for their consumers, which can be a citizen, a government, or a business. A lot of liability issues actually come up from this leg of the players, even though they are not a direct participant, but a lot of issues relating to litigation, relating to liability claims may also end up emanating from here. So this is like a broad representation of who the ecosystem players are. And this is what I will refer to during the course of my talk here. When we think about governance frameworks for data exchanges, broadly, there are two parts to it. One, of course, is your applicable laws, your Digital Personal Data Protection Act, depending on if at all the platform is dealing with personal data sets. We have the Information Technology Act, which essentially regulates intermediaries, and in most cases, platforms will qualify as an intermediary under the IT Act. And of course, you have sectoral laws depending on the data sets that are being sort of used or exchanged through this platform. Beyond that, we also have a lot of contractual agreements that govern the relationship between these key players. And these are the terms of use and data sharing or any other agreements. In fact, a lot of liability questions, a lot of risk questions are addressed through these commercial or through these contractual arrangements, and that's what we will see in the next few slides. Very briefly, before we get deep dive into some of these legal issues, sorry, I'll quickly talk about some of the key legal issues that often emanate, or rather, what are some of the key issues that one needs to think about when we are developing, designing, or deploying data exchanges. The first question is around data ownership, because you have providers which contribute data to a data exchange. I think the first question is that whether there is, whether the provider in fact has the right to contribute that data. There's a lot of legal theory around who owns the data sets, depending on whether it is personal data or whether it is non-personal data. But it is important to assess the ownership of data sets at the beginning, so that we ensure that any data which comes into the ecosystem is legitimate, is lawful. Second is ownership and usage rights. So when a provider decides to make data available on a data exchange platform, the question is, what is it, what kind of rights are being given here to a user who accesses that data sets? Is the ownership of the data sets itself given, or is it essentially a limited right to use that data? Typically, it is a limited right to use that data in most of the data exchanges that we see. The second point here is around data protection, and we will deep dive into it in the next couple of slides. But broadly, this is important if there are personal data sets involved, because again, the moment there is personal data sets involved, there are a lot of legal compliances that gets triggered in, and there are different grounds, different kind of compliances which have to be accounted for. The third important question in all this is eligibility criteria of participants. Determining who the operator of the platform will be, determining who can access the platform are also key questions from a legal contractual arrangement point of view. And so is also the question of roles and responsibilities of participants. I cannot overstress the fact that it's why it's important to delineate these roles and responsibilities in the beginning, because ultimately, when something goes wrong within that ecosystem, this is where questions of liability will redirect us to. Whether this happens through the terms of use of a platform, or whether this happens through other contractual arrangements, is something that parties can sort of eventually agree upon. The first point is around data quality and pricing. Very important, but at the same time, also a little bit of a tricky area. When it comes to data quality, I think an understanding of the standards and benchmarks should be very clearly set out in upfront, so that a lot of questions around a lot of liability issues sometimes come towards questions of the data qualities that are made, that of the quality of the data sets that are made available on the exchange, plus any products, any sort of solutions so which are developed based on that data. Pricing again is a question. I mean, it's very closely tied to what kind of data sets are being made available in the ecosystem. And we will again come to this in the next few slides. Liability attribution is something which will, I mean, there are different kinds of misuses, there are different kinds of, breaches that may happen. And how do we sort of have responses to each of these situations? What kind of risk mitigation strategies we have? It's not a question of figuring out where to put the blame, but rather to ensure that effective solutions can be thought about in case there is any harm, in case there is any breach that emanates from a data exchange. And this becomes more and more important as and more you have, government-backed data exchanges where people are relying on these data sets for critical functions. Again, another important is around intellectual property rights. Who owns the IP in the data sets that's contributed? Who owns the IP in the data sets that might be derived out of it, or the products that may be, or solutions that are made out of the data sets that have been accessed through the platform. And of course, last but not the least, is around the whole institutional architecture of how the data exchange governance would look like in case there is dispute, in case between parties, in case there is a grievance. How will all of these be addressed? Now, a lot of it we will not, existing laws do not have clarity on. What existing laws would essentially require is that you need to have some form of a grievance redressal. But again, in many cases, platforms and participants essentially decide what kind of institutional architecture would be relevant for the keeping in mind the purpose of the data exchange. Now we'll deep dive into some of the specific questions. The first question, of course, is in any conversation about a data exchange is what data is being shared, whether it is personal data or it is non-personal data. When we look at the digital person, and let's think about data in that two broad categories as personal data and non-personal data. The DPDP, or the Digital Personal Data Protection Act, has defined personal data to mean any data about an individual who is identifiable by or in relation to such data. It's a broad definition. Very often, many people sort of think that, okay, if name is not name is personal data, but everything else is not. But I think it is slightly beyond that. There is jurisprudence, as well as, there's a lot of legal jurisprudence as to how sometimes different data sets combined together can be used to identify a person, in which case, it is also possible for non-personal data sets to be combined together to be able to identify a person, which means that non-personal data sets can also lead to identification, and accordingly, can the Digital Personal Data Protection Act gets triggered. Again, right now, with India, because we are still evolving, this is a new law that we have, which is yet to get enforced because we are still waiting for the rules. Jurisprudence around this will develop, but I think as a starting point, it is important to identify and classify data sets as personal and non-personal. And mixed data sets, typically, because many platforms may also have mixed data sets, will require a dual governance mechanism, a governance mechanism for personal data sets and a governance mechanism for non-personal data sets. If there is a personal data involved, the next question that is often asked is if there is processing of personal data that is happening. So today, when you look at the Digital Personal Data Protection Act, and that the Act does get triggered when you process personal data, it essentially gives a very broad definition of processing, which means that processing can mean any automated action on digital personal data, including making data available. And there at times, even if an entity is just making data available, a question often arises because that's essentially what an exchange is doing, is that does it amount to processing of personal data? Again, that we there are of course ways and means to kind of deliberate on these issues further, but broadly from uh, an ecosystem player point of view, I think it's important to map all processing operations and define very clearly who performs what kind of processing. The third leg, in case, again, this is all relating to if there's personal data involved, if there's processing of personal data involved, the question is that who is a data fiduciary, who is a data processor? Today, the data fiduciary is the primary point of compliance or has the primary responsibility under law, which is the Digital Personal Data Protection Act for most of the compliances. That is to ensure that consent is taken, that is to ensure that data principals, that is the person whose data you are dealing with is able to exercise all the relevant rights that are given to him under the law. And then, of course, you have a data processor who is processing data on behalf of a data fiduciary. There are not many obligations per se under the Act for that, but broadly, what will happen is that in most cases, the moment there is a data fiduciary, and if someone is processing data on behalf of that data fiduciary, the data fiduciary will contractually try to sort of ensure that all its obligations under laws are also extended to it, to ensure that if there is any breach tomorrow, they can demonstrate that they had taken due diligence by ensuring that any processor that they had engaged also was supposed to comply with the applicable law. So it's important to clarify these roles contractually. Nevertheless, of course, if there is a breach of a law of personal data in any of these cases, there will be an independent assessment under law. And yes, of course, if there is fourth point, if there is personal data, consent or what is the basis for personal data is something that has to be evaluated because the Act again provides different grounds for processing personal data. Moving on, the next question is around what about if it's non-personal data? In many cases, today, what we see is essentially that the question that comes up in many exchanges actually, data is anonymized, which means that personal identifiers are removed. The only thing is that in the Indian law today, there is no express clarity, unlike many other laws in other countries, whether anonymized data is completely outside the ambit of the Digital Personal Data Protection Act, which means that because even in which means that the anonymization standards are essentially left to the party who's anonymizing the data. So I think it is important that in case any anonymization standards are adopted, it should have, there should be certain set out standards where re-identification of that individual is not possible. I think that is why contractually agreeing on the standards of anonymization becomes important, especially if the operator is if the platform operator or the data exchange operator relies on the provider to anonymize the data, and there should be a complete prohibition on re-identification. Globally, we see various data protection authorities have come up with standards for anonymization. In the Indian context, today the law doesn't give the data protection board with that similar power. So going forward, we have to see how, of course, anonymization standards in India also develop. And of course, if personal data is involved, there are compliances under DPDPA which become important. I'm not getting into the details of it, but yes, there are security standards, grievance redressal rights under DPDPA, but this is all contingent on whether the data sets that are made available on the platform actually qualify as personal data. Again, data quality issue. It is tied to the functional purpose of the platform. Um, in a lot of questions around liability, data quality is likely to sort of become an important issue. From an operator's point of view, from a platform operator's point of view, the more it gets involved in assessing quality, certifying quality, authenticity, it becomes more prone towards liability issues. So typically, you will see that in many cases, operators require providers to certify the authenticity and accuracy of the data sets. And it is important, very important to set out in the terms of use or any contractual arrangements what kind of role the exchange has, if the exchange has any quality control or validation role in the data quality point. Secondly, the other point here is around pricing. Again, there is not much legal and policy clarity around it, but it is again closely connected to the nature of data sets that is being made available. There are differential access and pricing points that can be considered. In any event, I think the broader point is that there needs to be clear pricing benchmarks. And of course, what is being priced? Is there a service that is being priced, or is it the data sets that are being priced? So I think there needs to be a clarity on these points. Of course, there are a lot of issues when it comes to pricing data sets. We will, I mean, personal data sets, absolutely no. For non-personal data sets also, I think this space is still evolving. But yes, this is also something that has to be considered while, if pricing is something which is a point in the data exchange mode of work. Participants. Here we'll very broadly talk about the role of each of these participants and how liability issues essentially gets addressed through their roles. In many cases, for the operator, the legal structure of the operator has to be examined. And we have seen this with some of the data exchanges, is that conversations around sometimes, in a lot of government-backed data exchanges, it is presumed that, let the government sort of, anybody can sort of become the operator or legal or the operator of the exchange. I think from a liability point of view, if you want to ring fence liability, you need to think about if a separate legal structure is necessary for the purposes of creating an operator for the platform. Second is the clarity on functionalities and services which are being offered through the platform. And another important part is that very clearly identifying permitted and prohibited use cases. Because once you identify that, it gives you contractual recourses in case there is any violation of these. Assuming, data sets were made available for purpose X, somebody went and they used it for purpose Y, ultimately there has to be some recourse for the platform operator to go after an errant party, and that is why these kind of clarity is necessary. As I said, the role of the operator in data quality and validation checks is something that needs to be clearly thought about from a liability point of view. And whether data is being made on an as-is basis is something that needs to be clarified in the terms of use or in the agreement. And of course, there should be certain rights which allows the platform operator to deny access or terminate access in certain cases. Secondly, for data providers, I think the eligibility criteria for data providers is important. You will want to kind of ensure that only certain, I mean, this is also one of the ways in which you can ensure quality. When you know that, only serious participants are onboarded, participants with a history of maintaining good standards of data is something that we know. So I think that's also one of eligibility criteria becomes an important factor for the purposes of ensuring quality. Again, liability, the data provider typically should be liable for ensuring legality and quality of the data being contributed. For instance, if data sets, that is why goes back to the question, if personal data sets are being onboarded onto the platform, the data provider has to ensure that compliances under the digital personal data protection are met with. If non-personal data sets are being contributed, it has to be ensured that the data provider has to ensure that it doesn't violate any existing contractual arrangement that it has, or or any existing law, such as maybe any IPR related laws. Again, there are certain kind of certifications that should come from the data provider, which is around the legal right to share their data, compliance with quality and anonymization standards, which ideally should be set up clearly in the agreements, and of course clarify the liability for defective or unlawful data. These are all sort of preemptive questions that needs to be thought at the time when the model is being designed, so that this can be agreed upfront as a part of a service level agreement. Again, requiring providers to tag metadata and provenance to establish data lineage and attribution also becomes important. From a user perspective, also, eligibility criteria of the user is an important point for the same reasons that we had discussed. Typically, a lot of data exchanges in India are made available for research purposes, for startups, to the startups or even government entities. And there is, of course, certain kind of verifications and checks that are done before any user is onboarded. And ensuring what kind of access they will have. Many platforms also give differential access rights to different users, so that's also another model that can be thought of. And for any sort of arrangement at a data user level, it is important to understand the liability that may, from a third party harm, that may come up due to solutions developed by a user. Again, these are also certain sort of clauses that are typically addressed in the terms of use or in agreements to sort of deal with any situation in case a third party claim has come due to some defective product that a user has developed using data sets from the exchange. For as far as data users are concerned, I think ensuring purpose limitation, meaning that ensuring that data sets are used only for the purposes for which it was agreed to, or for the permissive purposes that we had discussed earlier, is important, and that's an undertaking that is important from the data user's perspective. A prohibition on re-identification is something which is important, and of course, data deletion requirements, if any, has to be also thought about. Moving on to liability, attribution. Broadly, liabilities can be under existing laws if there is actually a violation of any statute or of any existing laws. Then, of course, the procedure under that law sort of kicks in. But there are also liability under contractual agreements. Sometimes, even for in case of any litigation, in case of any legal actions that come across against any parties of the ecosystem, whether it's against the data contributor, provider, data user, or the network or the platform operator, there are different risk mitigation strategies. There are different ways to limit liabilities through contractual arrangements. And this is what the next few slides we can talk about. Mostly when we think about liability, what essentially comes to our mind first will be around, what can be the liability concerns will often involve data breaches or unauthorized access. If there is a misuse of data, the data set was given for purpose X, but it was used for the purpose Y. Incorrect or poor quality data, non-delivery or delay, if there is a violation of IPR or any other law. Broadly, the principle that gets it sort of implemented at that stage, and I think a principle which we need to keep in mind when we are thinking about liability questions, is that it depends on the role, control, and causation. These three questions are the thing which will guide us to perhaps navigate questions of liability. First, who had the control over the data at the time of breach, misuse, or loss? Were there any statutory violations? What contractual obligations were in place? Now, in most cases, you will see that these questions of liability will get governed through layers of applicable laws, terms of use, and contractual agreements. And that's essentially how questions of liability get addressed. We've talked about some of these liability attribution parts in the first few slides, but I'll still go through some of them. And I think it's important, like to ensure minimize or mitigate liability. What is important from an exchange operator's point of view? I think the legal status under existing laws is something which we need to be very clear of, whether we are an intermediary, a data fiduciary, a data processor, and what kind of, accordingly, what kind of obligations we need to account for. Implementing security standards, breach, and incident reporting is important to demonstrate due diligence whenever a sort of a liability related issue comes up. We've already spoken about defining permitted and prohibited use cases and indemnity caps and limitation of liability. This essentially become important when there is a third party claim. For instance, from an operator's point of view, if there was a data set which was made available, let's say the provider did not take there was some personal data sets which was made available on the data on the platform, or rather, let's say a weak anonymization standard was used, personal data was made available on the platform. The data principal has now filed a claim under the Data Protection Act, and the operator is also sort of impugned in that claim. In such a situation, that it is useful to have these kind of indemnity caps and limitation liability, so that in case there is any legal proceeding, and there is any loss that the operator can operator incurs because of these kind of legal proceeding, that can be actually recovered from the data provider who in first place actually violated a contractual term, which was to ensure that it had taken the consent or it had complied with all applicable laws before contributing data sets. So I think having representations from the data providers, users, and clubbing that with these indemnity, limitation of liability clauses is important. Again, from a data provider point of view, as I said, it is from an operator point of view, it is helpful if the data provider is responsible for ensuring the quality anonymization standards, and because it will because it becomes easier in those cases to deal with liability issues. And for the data users, as again I was saying, that data must be used for authorized and declared purposes, prohibition on re-identifications, and if there is any action, and I think that's something which needs to come out clearly in the contractual arrangements, is that if there is any action that the user takes beyond the authorized use, any harm emanating from that kind of an action or unauthorized action is something that the data user will be liable for. These are some sort of an illustration. I mean, we talked a lot about, how liability can be addressed in different scenarios. We can apply the causation, control, and contractual terms, and we can try and understand in each of the following scenarios how that will play out. In most cases, as you will see, in case there is any breach, in case there is any violation of a law, it is not as simple as saying that party A is liable or party B is liable. There are always a series of questions that comes up the terms of use that will be referred to, the contractual terms that will be referred to, and based on that, all these questions of liability gets addressed. Just to give an example, imagine in illustration one here, there is a security breach in a platform, which results in a data breach. Now, the first question here, I mean, it doesn't automatically become the platform operators or the exchange operators liability, because the first question that needs to be looked at in such a situation is that did it emanate because of a technical glitch on the platform, right? If there was, again, let's say there was a technical glitch, did the operator have reasonable security measures implemented? So I think that's a second level question that comes. If they did not emanate from a technical glitch, then can this be attributed to weak access controls, either on the part of the user or on the part of the provider? So I think there is a series of questions that will eventually have to be answered, and all will get redirected to various documentation that has been entered into between the parties. And that is why we sort of spoke about some of the key issues, legal issues, or some of the key issues that we need to be mindful of when we are designing, developing these exchanges, and when we are preparing the documentation around it. The second illustration is, let's say, and this is relating to a third party harm, let's say, is that a data exchange was supposed to provide some real time data, a delay occurs, and a downstream user claims a loss because it relied on some timely updates and that the update did not happen. Now, the question again that will be asked is, what was the source of delay? Was it because there was a system outage? Was it because there was a provider uploaded it at a late, I mean, it was a late upload? Was there a force major event which was beyond everyone's control? And you will see that in most cases, typically your documentation around data sharing agreements or your service level agreements will essentially have to address some of these questions. The third example, again, if a data user uses data exchange to build a credit scoring model that discriminates or re-identifies individual. Now, what you do with the data sets that you access from a platform, I think it's important to clarify. That is why in the terms of use and in the documentation, that the exchange is essentially not liable for any use cases or for any uses of the data beyond what is permitted. So I think that at what point the exchange's role starts and at what point the exchange's role ends has to be very clearly set out, because there are a lot of interconnected issues here which can sort of become problematic in case there is a liability issue. And last but not the least, a lot of these questions around law liability, we have existing laws, obviously, which continue to govern it, but a lot of it is also agreed between parties at the time when this model is being designed. And typically, some of the key documentation here would be the terms of use, the website terms of use that most websites or platforms have. I mean, this essentially comes from a statutory mandate under the intermediaries rules. And these are very standard clauses. So typically many platforms usually just sort of have a boilerplate and just implement that. But I think it's important because a lot of questions around the roles and responsibilities of parties, who's liable for what, who is not liable for what, is something that gets addressed through the terms of use, which again also includes a privacy policy. Then there can be two data sharing agreements. One is a data sharing agreement between the platform operator or the data exchange operator and any kind of user, whether it is a provider, data contributor, or a data user. And this essentially sets out some of the commercial points, which one might not want to put it out as terms of use because that's publicly available. So you have those commercial points agreed on a data sharing agreement, and which often comes with a service level agreement, meaning that all these questions about, timely updates of data, data quality standards, data anonymization standards, all technical and operational points should also be agreed upon as a part of your service level agreement. And at times, exchanges also provide model agreements that can be entered into between a provider, data provider, and a user. So the operator is not a part of it, because at the end of the day, when the data contributor is, all that the operator is doing is basically acting as a conduit. But essentially, you might want to have providers, and users may want to have their separate terms in terms of how the data is to be used and for what purposes. So that is again another sort of a data sharing agreement that often comes. So these are some of the key documentation beyond applicable laws, which becomes very, very critical when we are thinking about legal and liability related issues. And I think the points that I spoke about earlier needs to come in some form or manner in these documents. So yeah, with this is the end of the talk. Thank you so much. That's it. Over to you, Jyotirmay. I think if anyone has any questions, I'm very happy to answer that.
Hi, Shehnaz. Uh,
Yes, hi.
sorry, Shehnaz. I think I was muted. So is cryptographic data also subject to the compliance controls under the DPDP? When I say cryptographic data, data that is encrypted. Yeah.
Sorry, I was on mute. Sorry. I think the DPDPA makes a very there's a simple test. If you know the data which you are using for the purposes of the if the data that is made available can be used to identify someone, then yes, it is. But assuming if post encryption, there is nobody can take a look at the data, nobody can identify an individual by looking at the raw data itself, then perhaps DPDP will not get applied. But again, having said that, we are still at the stage where the jurisprudence around what actually constitutes personal data in the Indian context is still being developed. But the simple test is, what I just mentioned.
Okay. Okay. And I just had a follow-up question. Is the data exchange also responsible for the enforcement of ownership of the data set? Like, say, suppose there can be a case where a data provider is a partial owner of that data resource, right? So, is the data exchange also, responsible to enforce that?
So having said that, as I was saying, I think the more the data exchange, it's a call that has to be taken. The more the data exchange gets involved in ensuring ownership, quality, legitimacy of the data, the more it sort of opens itself for liability questions. So typically, in most cases, and this is again purely from a legal perspective, is that when you are preparing the documentation around the data exchange, it's important to ensure that whoever is contributing the data certifies that it has the right, or that it is not in violation of any law or agreement when it is contributing the data. If the data exchange essentially gets involved in ensuring that the provider has ownership or has control or enforcing that, I think that's where the problem sort of I mean, from a liability question, that sort of the data exchange operator gets entangled in liability questions if tomorrow there is a third party claim. So for instance, let's say there was the data provider sort of provided data sets over which it did not have any ownership. It was there was and or as you said, some partial ownership. but and there is a third party claim saying that, okay, this was in violation of this particular agreement because this data provider did not have the right to share the data. In that case, the third party is likely to get the data exchange involved in that proceeding. However, if the data exchange can sort of have contractually agreed with the data provider that, listen, you had certified that you had the right to share the data and you violated that contract. So if I suffer any loss now because of this third party claim, you will compensate me for that claim. So I think that's how it will usually work in this scenario.
Yeah. Thanks, Shehnaz. Any other questions? Shehnaz, you mentioned about this while anonymizing the personal data, you mentioned about the irreversibility standards, right? Uh, so, so I want to know, like, who decides these standards, right? I mean, the technical standards, and then let's say there are multiple standards, there has to be some consensus that, okay, this is what we agree on. And especially in anonymization, there are parameters which could be tweaked, resulting in how much the data has been anonymized. So can you please? Yeah.
Yeah, thanks, Jyotirma. In fact, I feel like this is actually a legal gap in the ecosystem,
Hmm.
when it comes to the Digital Personal Data Protection Act. So globally, also, when you see, because you're right, what exactly is an irreversible standard? What exactly are the standards of anonymization that we should meet to say that, okay, now this data is completely anonymized? Because we don't have we don't have uniform anonymization standards which are backed by any law or policy,
Hmm.
which entities can adopt. So then the problem here, I mean, and also if you see, the Digital Personal Data Protection Act doesn't really clarify, unlike a lot of earlier versions of the bill, which had actually said that anonymized data
Hmm.
sets will not be personal data, and anonymization would mean anonymization as per standards issued by the Data Protection Authority, in which case it was obviously easier. Parties could have claimed that, okay, we
Hmm.
follow the standards that was given. So in which case, this is not
Hmm.
something, if something goes wrong also. The problem here is that even with anonymization, and I think you guys will be in a better position to tell me, is that you can always have, technical improvements as and when technology improves. There is always a possibility of,
Hmm.
re-anonymizing, which means re-identification of that
Correct.
data. So I think,
Yes.
yeah, that's where the problem sort of comes. So I think when at the point right now, in the absence of any legal clarity on that, I think it is important that, whenever there are anonymized data sets which are coming onto the platform, upfront, I think there should be some form of standards that are agreed to. And there, even if, let's say, even irreversible, I mean, I think there should be an obligation on the providers, if they are anonymizing the data, that, the standards, and it has to be a broad principle that if they are anonymizing the standards based on whatever technology is available today, they have to a certain extent, certify that, you cannot re-identify. I know this is again a little bit of a tricky
Hmm.
situation because nobody will contractually, it might be difficult to implement it,
And
but that is one way for
yeah,
the
but
operator. Yes,
correct,
sorry.
correct. And as a data exchange, like, how do we ensure what you call purpose limitation? Because see, once the data has been accessed, right? Uh, Essentially there's no control which we have, like technically there's no control, right? So how do you enforce a purpose limitation here? I mean, is there any legal implications of that?
No, so as I said, I don't think it will be technologically, I don't
Hmm.
think it will be possible for you to
Hmm.
ensure that purpose limitation. And that is where
Hmm.
your legal documentation comes.
Hmm.
There is so much that technologically you can do within the ambit of, or as being the data exchange operator. The
Hmm.
moment,
Hmm.
and that is what you need to basically, I mean, what the operator needs to specifically set out is that this is what is allowed with the data and this is what you cannot do with the data. Now,
Hmm.
anybody who does anything beyond,
Hmm.
beyond that, let's say any data sets is being taken and use for some unlawful purpose.
mm,
Technology cannot do anything about it, but let's say that, you can always legally proceed against that entity
mm,
because you had set out, what can be and cannot be done.
right, right. And you gave very nice illustrations at the end, right? So the second one was about real time data or streaming data, as you say, right? And we
Yes.
have been dealing with streaming data as, and one of the use cases is for green corridors, right? And corridors for emergency vehicles, basically, which are completely automated. There's no manual intervention, and sometimes this question has come to us like internally, that what if some data packets does not reach on time, right? uh,
Mm.
you have very well gave these three sort of use cases or illustrations, but then the question still remains that, let's say that who will be responsible for that, especially these kind of use cases which are very critical, yeah.
No, I agree because, that's what I was saying. It's when it comes to who is responsible, it's never, in law, it'll never be a clear answer. That it's not like, if the data was supposed to, if there's let's take the example of the real time data, right?
Mm,
I mean, the questions of liability obviously come in when someone on the other side raises that issue or claims that, okay, fine, there has been some breach here, right? So, and
mm,
that's when you will go back to this, all these questions, like, at your
mm,
service level agreement, that's why I have to agree that, and you will have to envisage that, there
mm,
are certain things that are beyond my control. Like, for instance, and that is why, legal documentation is where it becomes critical that,
mm, mm,
there are certain things, if the delay is happening because of so and so
mm,
reasons, which is within the ambit of the platform, then yes, I will be liable for that delay. But
mm,
let's say if the delay is completely something which is beyond my control at all, then I can obviously not be
mm,
responsible for that. And that is something which the law also recognizes. So
certainly.
I think in these questions of, of liability, the first thing is that, the moment first is that somebody has to bring a claim. When somebody brings a claim, then you have to go into your service level agreements to determine, or your agreements to determine, why did the breach happen, and
Mm,
or rather, why did the delay happen, and depending on that, your liability question gets addressed. If, let's say,
mm,
if it was not, I mean, in your example itself, sometimes it might not
mm,
be completely due to, it might be, sometimes it might be due to a glitch in the system, in which cases a lot of legal documentation does make, sort of will account for those kind of errors that happen, and within what period that can be taken care of. So I think that is where the legal documentation part of things becomes tricky, because liability questions will never be very straightforward, and you cannot give a straightforward answer that yes, the operator is responsible. Depending on who's designing those documents, from an
mm,
operator's perspective, you have to keep in mind that, these are the things that I can control, and accordingly I can be liable, but these are the things where I should be a little bit more careful and sort of perhaps have limitations of liability clauses in there.
mm, mm, mm. Yeah, and of course we have still not, touched the, the elephant in the room, which is, people using this data exchange data and training their models, right? Because that's a different, story altogether, right? Because, data as is, when it is stored or when it travels, the protocols, technically, the policies are very well set, but now the general notion in the community is that what do you do, can you keep the data private, the privacy intact, and at the same time train some models, right? So of course there are
Hmm.
ways to
Hmm.
do that math, there are techniques to do
Hmm.
that, but again, these are very
Hmm.
areas where it becomes more and more complex, as you, from a policy and governance point of view, the more you get deeper into these things. But yeah, but I think,
It
that's.
does. I
Mm,
mean, just to sort of add on this part, because this is something which has often come up in the context of different laws. As even in the Digital Personal Data Protection Act, if you see, there are provisions which allow personal data to be used for research purposes. Now, a interesting question which has often come up is that is model training, if models are being trained for research purposes, is that covered under the Digital Personal Data Act? So let's say if going forward, METI takes a view on this, then one can argue that, and there are of course standards that have to be met when you're doing that, but whether that's something that can be considered. Similarly, there are various laws in different countries which allow you exceptions for data mining under copyright laws, right? So I think there are, it's not very clearly come out, but generally there has been a recognition of when certain legally protected data may be used for model training. But of course, having said that, everything there itself has to be subject to certain standards.
And where do you see DPDP vis-a-vis GDPR? Like, I mean, are they both like similar?
No, I think there's a lot of difference, and I think one of the biggest, and I mean, there are a lot of differences, of course, which are there in terms of compliances, in terms of how data sets are being treated. But I think one of the most important things, I think, which we perhaps did not address is this anonymization point, because that is essentially anonymization is being used by a lot of people for training data sets in the
Yes.
AI ecosystem, for making data sets available. And we don't want a situation where people are sort of using standards leading to re-identification, and then people are, it's
Certainly.
uncertainty for everyone. So which I think EU has addressed in their law. So yeah, I think that's one point which I would really think is important.
Yeah. Thanks. Yeah. Anyone else? Please unmute yourself or raise your hand and please ask your questions. All right. I believe there are no further questions. And thanks, Shehnaz, for your time. I know you have been occupied, and unfortunately, you won't be able to join our symposium as well, right? We would have loved to have
Yes,
you
yes, yes.
in the symposium.
I know. I am
Mm.
also a little upset that I can't join you, but yeah,
Uh,
hopefully we'll catch up some other time.
Sure, sure, sure. And to all the participants, thank you for your time to join this session. And I would like to invite all of you on behalf of the Center of Data for Public Good to come and join this annual symposium. It's a big event spread across 2 days. I've shared the link in the chat, right? Please log into that. And in case if you have any issues, feel free to drop an email to me, and we can respond. And looking forward to meet all of you guys there. All right, Shanaz, I'll close the call now. Thank you so much. Yes.
Yes, thank you so much. Thank you. Thank you, everyone.